Welcome to the NYU Latham and Watkins Forum. It is a delight to be here with what I'm told is a record crowd, or very close to a record crowd, to welcome Commissioner Mark Meador from the Federal Trade Commission. Before we burst into a spontaneous rapture of welcome, I want to say a couple words of introduction. This is not just a professional pleasure for those of us in the antitrust group to welcome Commissioner Meador here. It's a personal one for me. We have been friends and colleagues in the antitrust world for a number of years now. Commissioner Meador is a veteran of the Federal Trade Commission, the DOJ Antitrust Division, the Antitrust Subcommittee of the Senate Judiciary Committee, State Attorney General enforcement in Texas, and private practice. And on top of all of that, he has a separate full-time job as a dad to 6 children, with a 7th imminently on the way. So I'm told that if he leaps to his feet and runs for the door, it'll be because he's received a message that the 7th child has arrived, not a reaction to anything that we have said. I'm preparing to be a dad for the first time, and there's something very comforting about knowing that parenting 6 or 7 is even possible. So thank you for the spiritual encouragement. But it's not just the record of enforcement and public service and antitrust work that makes me so excited that we're welcoming him here today. Commissioner Meador was talking loudly about the need to reinvigorate and support antitrust enforcement, both at government agencies and for private plaintiffs and consumers, long before this extraordinary moment of antitrust popularity, and certainly long before that was a popular position to take on the right-hand side of the political aisle. When he was on the Hill, Commissioner Meador was a very strong supporter of the work that we at the antitrust agencies were doing. And among other things, he was right at the heart of the bipartisan efforts to pass and develop antitrust legislation aimed specifically at tech markets. And I think some of the earliest conversations I ever had in the antitrust world about the importance of enforcement in digital markets were with Commissioner Meador. Today, as the newest member of the FTC, he's one of the most prominent voices calling for rethinking and reinvigorating antitrust. His 33-page flagship speech, Antitrust Policy for the Conservative, is, I think, the most extensive and explicit statement of antitrust philosophy on the right-hand side of the aisle that we've seen for years. If you haven't read it,
there's not a lot of competition.
It's a natural monopoly. If you haven't read it yet, I encourage you to do so. We're going to cover a ton of ground today, from the future of the FTC to tech markets, Humphrey's executor, your background and vision for antitrust. But before we do any of that, please join me in welcoming Commissioner Meador to NYU.
Having gone to law school, I know you're all mostly here for the free lunch, and I assume that means that Daniel did a very good job of picking an option that beat out whatever was competing with it.
So I want to start with a really basic motivating question. So you've done almost every job in antitrust that exists. What are you in the antitrust game for? What drove you to it? And what do you see the system as, in its bones, doing for us?
That's a very good question. So I think maybe one way to address that is to talk about kind of how I stumbled into antitrust. As I was telling some students shortly before this, I took antitrust as a 2L in law school. When you first get to pick what class you want to take, and not just the stuff that's set for you, and fell in love with it right away. I think there were questions of political economy, political philosophy, economic fairness involved in antitrust law, and reading some of the older cases and the legislation that spoke to me. And I think it's worth mentioning that this was in 2009. So in the middle of the Great Recession, there's a lot of discussion about how our economy is structured, whether it's structured fairly, do we need changes to the law? And so a lot of these questions were really top of mind. And when I started reading antitrust cases and talking about it in class, just found it endlessly fascinating, and decided then that was the career that I wanted to pursue. And as far as how I view the system now, whatever the system is, but I think, look, if we're talking like antitrust philosophy, my approach is enforce the law, right? That's really where I come at it from, is looking at the text of the statutes and enforcing it, applied to the facts before us. And I think, well, I'm sure we'll get into the details of this, but one of my criticisms is that a lot of antitrust enforcement policy and thinking, especially on the right, about antitrust, has been divorced from the text. It has not actually been, for all the talk within the conservative legal movement about originalism or textualism, for some odd reason, that stops as soon as you get to antitrust. And then we're in this awkward position where, we kind of like the policy outcome here, helps large corporations, so we'll just kind of pretend like this isn't an issue and move on. And that just never really aligned with my own sort of personal political philosophy and political instincts. And I don't think it aligns with the text of the statutes. And so, the way that I approach antitrust law is very much through that lens of what does the law say? What is the policy that the people through Congress have enacted? That's what we have a duty to enforce.
So I spend a lot of time encouraging people who don't think that antitrust is or might be for them to jump in and give it a try and realize that it's a place for deep disagreement and not just for sort of certain kinds of technical economic analysis, which for sure are important, but also for questions of political theory and moral philosophy and questions about the nature of a shared social enterprise. And in thinking about sort of antitrust as that pluralistic, multidisciplinary project, it's kind of interesting to me that your undergrad background is in philosophy, if I'm remembering right. Is that something that is in any sense like formative of your perspective on antitrust, or is that a different part of your brain?
It's definitely not like a separate part of my brain. I think it certainly informed, like I said, the way that I kind of approach political philosophy definitely informs how I think about antitrust policy. If you read the legislative and public debates around the antitrust laws at the time that they were enacted, starting from the Sherman Act through the amendments to the Clayton Act, it's not limited to maximizing output, reducing prices, creating efficiency. Like that barely prices factor into it. There are complaints about consumers being subjected to monopoly pricing, high prices, all of that. But it's really nested within this much broader conversation over political economy and economic fairness and what the role of the government is in ensuring that markets work to the benefit of the average person, not just large corporations. And then the question is, how do we achieve that result effectively and fairly? And one of the themes that I explored in my paper is balancing this, because I think that is potentially where you see a divide between the left and the right, where certainly today there's some shared impulses within sort of this large umbrella of economic populism. But when it comes to the means by which we would pursue any of those ends, there's a lot of variation. And I think that's one place you have a divergence between left and right within this discussion, is what is an appropriate way to go about this. One of the things I think that Judge Bork did get right is this idea that we don't want unelected, lifetime appointed judges making decisions about the structure of our economy and about allocating economic benefits between competing constituencies. That's really a fundamentally political question, and we have one branch of government that has been entrusted with the responsibility to make those allocations of benefits between varying constituencies, and that's Congress, obviously. And so they are the ones that set the policy, and then we enforce it. And so to me, the most interesting question within the antitrust realm is, how do you balance what is clearly the animating idea behind antitrust law as a discipline, that we want to limit concentrated economic power, that we want to promote certain notions of fairness within the economy, with the need for judges to have relatively clear articulable, administrable principles to enforce and apply the law? How do we get to a place that achieves the ends that motivated the Sherman Act in the first instance, with the fact that we don't want to give an Article III judge broad discretion to decide how industry should operate and what's economically fair? And the way I come down on that is really, it comes down to balancing, how you approach the question of over deterrence versus under deterrence. And I think, we've seen variations of that over the last century or so. Initially, Sherman Act was narrowed. It's why you ended up with the Clayton Act and the FTC Act. By mid 20th century, we had an expansion where the government, one of the justices quipped that, all he could understand of the antitrust laws was that the government always wins.
Justice Stewart.
Yes. And so we saw that in the middle of the 20th century, and then by the late 70s, we see the emergence of the Chicago School, and things kind of get constrained again. And so we've had this back and forth. And I think, in recent decades, we've been through an era where there's been an excessive emphasis on avoiding over-enforcement.
So this is exactly what I wanted to ask you, which is the rubber meets the road in what I take to be the invisible villain in your story, which is, hey, we've been doing things wrong in a way that, needs perhaps to change for some decades, right? And that's a narrative that I see on both the left and the right. Let me ask you, what concretely do you see having gone wrong in modern antitrust enforcement? Is it sort of all reducible to, hey, we've become unduly worried about over-enforcement and we've forgotten that under-enforcement is its own kind of harm? Or is there something deeper that you identify as the source of the error?
I think that's part of it. I think that there is a lot of concern within the judiciary about getting things wrong, right? If you're a judge, I think a lot of judges, and this is probably generally a good instinct that we want judges to have, but they're concerned about false positives, and certainly like sending somebody to jail who's innocent is the biggest worry. But then maybe a couple rungs below that is, blocking some transaction that could have been economically transformative and created all these benefits for people. We don't want to get in the way of that. We don't want to stop something good from happening. And I think that sentiment has been present in the sort of the political appointees of the enforcement agencies for a number of decades, where there was just this heightened concern. It's a combination of things. It's a heightened concern that we don't want to get things, we don't want to have false positive. We don't want to get it wrong, but we certainly don't want to get it wrong in the direction of stopping something good, and by saying that it's bad. But I also think, there was sort of a philosophical mindset that put undue emphasis on certain efficiency claims. If you read the antitrust laws, especially look at Section 7, may be substantially to lessen competition. It's a very flexible standard. There's incipiency baked in there. It doesn't say when the government can prove that a merger will harm competition, a court should block it. It's when we can bring evidence to demonstrate that the effect may be to substantially lessen competition, the court should block it. And at times it has seemed like the standard has been inverted, where the government has to, with some heightened level of certainty, prove that a merger will be anti-competitive, whereas the defense can come in and say, we think we'll probably have these efficiencies or benefits, and that's the way it's viewed. It's been reversed, and I think that was encouraged and adopted as well, again, by some of the political appointees who are making these decisions about whether to bring a suit or not in the first place. And what we have now is, several decades of practice of that approach, and we can see the results. And to me, I think the fundamental question that I would tell people to ask, and I think people ask themselves, when you're thinking about antitrust law, are we doing it right, and just economic policy broadly, and this is why I think things are changing now, is because the average person looks at the world and they ask themselves, do I think that this economy is working for me? And we're at a point where more and more people are saying no. And it's people on every political dimension you can imagine share this sentiment. And that's why we've gotten to a point where we can start to reconsider some of these assumptions we've had and say, hey, maybe this isn't actually the best way of going about this. Maybe this isn't the best enforcement policy. Maybe we got it wrong. Maybe we've been ignoring the text of several statutes for a century. And if we've been following the policy that Congress the elected branch of government had put in place, we could have avoided a lot of this.
So that leads directly to something that I think we'd love to hear your perspective on, which is antitrust politics right now in the United States. So on the left, or maybe to zoom all the way out, my sense is that we're witnessing a very deep reorganization of politics in the United States, away from a traditional, Democrat-Republican binary and towards a model where sort of populism and non-populism become the first order sorting principle of at least some of our political conversations. In antitrust on the left, I see a sort of a split between traditional, what we would call post-Chicago antitrust scholars who effectively accept the economic welfare-focused frames that have dominated antitrust since the 70s and 80s, but take those frames and apply them in a way that's more worried about risk, a little bit more leaned forward into enforcement. And then the other camp on the left, we might think of as the neo-Brandeisian group, who have a pretty deeply different vision of antitrust that is rooted not in specific identifiable welfare harms, but in a deeper concern about enduring asymmetries of power. And then on the right, where there has traditionally been, at least in recent decades, much more skepticism of intervention in markets, I see a similar sort of reorganization happening between those who still favor what we might think of as minimal intervention, and then a new school or a new set of schools that's sometimes called New Right or Conservative or America First. So I suppose I have two questions for you as I think about that landscape.
Just for the record, conservative is a term only used by liberals to describe conservatives.
Okay, all right. So as I think about that political reframing, number one, is that the right way to think about antitrust politics right now in this moment? And number two, where do you think of yourself in that political space?
Yeah, so I think more than a spectrum, I'd say it's like a quadrant, right? It's sort of, you kind of have, there's a rift within each party, and essentially it's a neoliberal wing within each party, and then a more populist wing as well. But then you still have the right-left divide, and as I was alluding to, I think a lot of that comes down to how far you would go, what means do you think are actually appropriate. I think, for example, one of the disagreements that we could explore between right and left within the more pro-antitrust enforcement crowd is sort of like, what's the purpose of antitrust, right? Is it a panacea for all economic ills, or is it targeted to specific issues and more limited in its scope? I think I would definitely put myself on more of the new right side within the right side of the political spectrum. Don't feel young, but compared to people that have been in charge on my side of the aisle for a long time, on the younger side of things, and I think more attuned and exposed to some of these changing economic realities. It's very easy, that question I mentioned before, like, is the economy working for me? Like, my baby boomer parents are doing just great, right? And I think that's probably a common sentiment within that generation. And so it's easy to look around you and say, I feel fine, nothing's going on, I'm doing just okay. And that has not carried over from generation to generation. That is another thing that I've witnessed, is that there's a generational divide in this debate as well. Hopefully that kind of addresses it.
It does. One thing that would be, as we think about the difference between left antitrust or economic populism and right antitrust economic populism, a lot of the attention, a lot of the energy around the return of interest and attention to antitrust sort of comes from or was organized around the neo-Brandeisian movement on the left. Your vision, as I understand it, shares at least some concerns with some of the themes that neo-Brandeisian scholars and writers and advocates have emphasized, including taking seriously the idea of power asymmetries, really refocusing the antitrust project on those who perhaps have not been at the center of what we might think of as the consumer welfare antitrust discussion. How do you, sort of your personal antitrust vision, how does that relate to, contrast with, overlap with the neo-Brandeisian project on the left?
Sure. the annoyingly clunky language we would use on the Hill is that I think we would say the neo-Brandeisians are directionally right. They're directionally correct, to be clear. Yes, generally you're correct. We've had under-enforcement of the antitrust laws. That is bad. It has caused harm. We need to fix this. And then, as I mentioned earlier, there's some separation in how we would go about it, how far we would go. One analogy I've used with a few people is kind of comparing it to like, if you're in battle and some young soldier comes up and just jumps out of the trench with a machine gun and starts spraying bullets widely running into the field. That's one way of doing it. But yeah, I would compare that to that's sort of like the neo-Brandeisian approach to antitrust is just pick up the biggest gun and shoot it at everything that moves. And folks on the right are saying, yes, we need to attack the enemy, but we should be strategic and thoughtful. Maybe we should use some snipers and not just wildly spray bullets everywhere and potentially have friendly fire and things like that. And so that's a somewhat pejorative way of saying, I think that the right still retains a very heightened emphasis on the rule of law, that process does matter. I know sometimes it's Matt Stoller likes to dismiss this as process trolling. And I'm sorry, but like we have a constitution, we have the rule of law, process does matter. I want to achieve economic fairness in the country, but it doesn't have legitimacy if it's simply the raw exercise of power against people you don't like, right? And so we have laws. We have laws on the books that were written with that goal in mind. We have a way of enforcing them. We have procedures to ensure that it's done correctly and fairly, and we should follow those procedures so that we not only achieve economic fairness, but we do it in a legitimate and a lasting way.
So am I right to hear that then as a sort of a modesty or a limitation in the scope of the project or its relationship with background rules of law or institutional processes, that kind of thing?
Yes, I think that remains a very important aspect of how the right is approaching these questions.
Okay. So that's a great segue to start zooming in a little bit on institutions and specifics. I realize that having done all these different things in antitrust, you're now just about settled into a new job as a commissioner. Before I ask you a bunch of questions about the FTC, like what is surprising you about your experience on the job? Is anything suddenly becoming clear to you from that office that wasn't clear at the staff level?
The most surprising thing has been how many times I've been asked that exact question. Actually.
Really?
Yeah. I think almost every staff meet and greet, someone has asked me, what's been surprising? Yeah. Which is a little weird because I worked at the FTC before. So on the one hand, like, well, not a lot. I mean, I wasn't a commissioner, obviously. I think maybe the most surprising thing has been just the sheer volume of information that goes across my desk on a given day. Learning the consumer protection side of the agency as well has been new and exciting. But I think that's probably the main thing is just like there's a lot of stuff going on. We do a lot.
So that kind of raises the natural next question of why would you take the job? As you say, it's sort of a lot of work, and public service is a burden as well as a wonderful privilege. What are you hoping to do? Do you have an objective or a goal in mind?
I mean, like, I'm kind of a self-described antitrust nerd, and who could pass up the opportunity to have a direct hand in shaping antitrust enforcement policy? I mean, I've had these views on what I think we're doing right and what I think we're not doing right for a long time, and it's a once-in-a-lifetime opportunity to help put that into practice and kind of put your own effort and resources where your mouth is and make good on it.
So let's zoom back out a little bit and look at the FTC as an institution, because this is a really complicated time for the present and direction of an institution where we've both worked at different times and that I think we both love. The legal status, the independence of the FTC is right now coming before the Supreme Court. I'm sure many people will be right up to the minute with it, but for those who haven't followed the timeline, see if I can get this right. In March, the president fired the two Democratic commissioners. I think both, but certainly Commissioner Slaughter is litigating that matter right now. It's before the Supreme Court. There's been some back and forth about the status of the stay. She's not currently in the role. When I was at the FTC, under Chair Joe Simons, the independence and bipartisan nature of the FTC was a really central feature of its identity at that time. And it was something that, sort of for all its process costs and occasional frustrations, I thought added a lot of value to the ways in which the FTC ran its investigations, designed its complaints, and then litigated in federal court. Now, I'm not an Article 2 theorist, and I don't have an informed view about the compatibility of independence with Article 2, but my experience in a concrete way was there was something distinctive, valuable, and complementary with DOJ about an institution that was set up that way. But even though I'm not an Article 2 theorist, I can sort of read enough of the Supreme Court's administrative law output to get the sense that Humphrey's executor might not be long for this world. So that's all by way of prelude to asking you, like, what do you think about the question of independence for the FTC? Is something lost if Humphreys falls? Is this an easy question of either law or policy? How do you feel about the FTC as an independent agency versus an alternative trajectory as a fully executive one?
Sure. A couple thoughts on that. I mean, at the outset, I think you allude to Article 2 and all executive power being vested in the president. I think it is essential to, when we live in a democracy, that we have democratic accountability for law enforcement. And there's simply no doubt that the FTC of today, whatever it looked like in 1935, exercises substantial executive power. And it is not right, under the principles behind our Constitution, our democratic values, that some substantial portion of law enforcement be immune from democratic accountability. That if the people don't like the way the law is being forced, they can elect new leaders who will pursue a different policy. When you have officials wielding executive power that are insulated from that process, you are working against the rule of law. All of that said, when I think about what that means in practice for the FTC, it's sort of everything is different, but everything's the same, right? So, we are no longer an independent agency. Arguably, we never were, would be, I think, the position of this administration. We have accountability to the president. We can be fired, which means that if we are pursuing a policy at odds with that the people have chosen through the electoral process, we can be removed and replaced with somebody who will pursue that. But as I said, in my confirmation hearing, and as I've told to staff, I view my job the same. I'm doing the same thing on a daily basis. I think they all are and should be doing the same thing on a daily basis, which is to enforce the law to the benefit of the American people. And that's what we've been doing. Even without Democrats in the building at the commission level, there are definitely Democrats in the building, just not at the commission level. There's a diversity of views, right? There are three of us there now. We work to attain unanimous outcomes as much as possible, which is true when you have 5 commissioners.
Sure.
But we don't approach things the same way. And we've had disagreements, and we have different ideas, and we would have different solutions to various problems. And we try to find something that is a consensus view that we think achieves a common goal. And I do think that is something that has always been true at the commission, is that there's always a shared goal. People rarely disagree on the goal. It's just what's the best route to get there. And so we still do have that deliberative process, even in the state where we're coming at it from one side of the aisle.
One forum in which I'm used to emphasizing the benefits of the commission's unusual structure is in a conversation about, wait a minute, what are we doing with 2 antitrust enforcers, the Department of Justice Antitrust Division and the FTC, in a world where sometimes, it's a matter of public record, those 2 agencies have not seen eye to eye. And in fact, while I was at the FTC, we were litigating a case against Qualcomm, and the Department of Justice opposed that case in court and then won. In a certain sense, Qualcomm obviously prevailed, but along lines favored by the Justice Department. And even I, sort of committed defender of the FTC though I am, recognize that there are aspects of a 2-agency model that look inefficient or undesirable, even though I would go to the wall to protect the FTC's enforcement authority. Having said that, in a world where the FTC is no longer a bipartisan independent creature, and where it's no longer possible to say, hey, let me tell you about these two complementary institutions designed in different ways that produce different kinds of internal process and perhaps focus on different substantive areas and contribute value in different ways. The more that the FTC starts to look like DOJ, the weaker that argument gets. So I guess the sharp end of this is, in a world where Humphrey's executor does not survive, the FTC is declared by the Supreme Court to be a regular order executive agency, does that fatally wound the case for two co-equal antitrust enforcers?
No. Getting to what I was talking about earlier and looking at the text of the antitrust laws, and you and I have talked about this previously, how there's been this trend over time of Congress enacting an antitrust statute, the courts watering it down, so Congress enacts another stronger antitrust statute, courts water it down, et cetera. The FTC Act is one of those, right? The FTC exists because Congress was not happy with the initial application of the Sherman Act and wanted stronger principles to go into effect. And so, we don't enforce the Sherman Act. We enforce Section 5 of the Federal Trade Commission Act. Now, we've gotten to a point over the last 109 years where there's been a lot of convergence, right? And so typically when we plead something, it's, this would violate Section 2 of the Sherman Act, and therefore it violates Section 5 of the FTC Act.
And just for those who may not be deep in the weeds on Section 5 of the FTC Act.
No, don't tell them, make them go look it up.
Tell us a little bit about Section 5 and
So Section
and how that's
5 prohibits unfair methods of competition, which has always been understood to be broader than the restraints of trade and the other phrases in the Sherman Act. And the idea, the way I've always viewed the FTC Act is we have a broader remit with more narrow remedies, right? We are primarily focused on injunctive relief under unfair methods of competition, which makes sense because if you're going after something that's potentially novel, you don't want to saddle somebody with treble damages and the potential for follow-on lawsuits and all of that. But it ensures that there is a cop on the beat who is looking out for conduct that is harming competition, but yet may not meet the standard the courts have developed for Sections 1 and 2 of the Sherman Act. And so this is a unique feature of the agency. I think the existence of people like me, non-chair commissioners, I'm busy, but I'm not as busy as Chairman Ferguson, who has an entire agency to run. And so I have the bandwidth to do things like this, to write 33-page papers. I think the FTC has always been viewed as my DOJ friends are going to get mad at me for saying this, but more scholarly agency, and we have a role. And
that is correct.
We have, it's backed up by the statute. We have the ability to conduct studies on markets and industries to better understand them. And that was always the vision for the FTC, is to be an expert on competition across the economy, to inform enforcement efforts, to inform lawmakers, to inform other agencies involved in regulation. And so we have a very important role to play there, both in fulfilling the mandate of Section 5, capturing things that maybe have been escaping notice under the Sherman Act, to fully protect competition across the economy, to inform lawmakers and regulators. And then, I can't fail to mention, we have Consumer Protection Authority as well, right? And the interaction between competition matters and consumer protection matters, right? In the same way, as more of anyone that's done antitrust enforcement, that criminal investigations can lead to civil investigations and vice versa. Merger matters can lead to conduct investigations. There's the same sort of interplay between consumer protection and antitrust enforcement, and it gives us another insight into the economy. And both prongs of Section 5 are built around notions of unfairness. And so there's a common thread there when we're looking at conduct across the economy, and whether it complies with Section 5 is this unifying theme of unfairness. And so, I think it makes a lot of sense to have an agency like the FTC in that role with sort of a bird's eye view over all those matters.
So from that perspective, if the distinctive magic of the FTC lies in that language of Section 5 of the Act, this unfair methods of competition provision that has always kind of been a mystery, right, about its scope or internal content, am I right to hear in that a vision that calls for a reclamation or an expansion of what we sometimes call, and I see the lights fading around us at the mere mention of Section 5. Okay. See, the content too dangerous. They don't want you to hear about Section 5. Good. Am I right to hear braided into that a vision for a reinvigorated, revived, augmented Section 5, reaching things that are not antitrust violations under the Sherman Act or under our Clayton Act, but which nevertheless might be subject, on whatever grounds one might find unfairness, to enforcement under Section 5. Is that your vision?
Possibly. I might stop at the word, and I wouldn't go so far as to say expansion, but what I would say is, a recovery of the statutory mandate that the people have given us through Congress, making sure that we are using all of the tools in our toolbox, to carry out the administration's agenda, to fully protect consumers in every way that we can. And so, yes, I think, we need to return to the text of the statute, develop it in a thoughtful way. There have been 2 policy statements on Section 5 in the last 10 years. The first one in 2015 essentially neutered Section 5 and said that apart from invitations to collude, it's essentially the same as Section 2 of the Sherman Act. And then we had whatever the 2021 policy was, which in my view was just sort of a jumble of words that replaced one unclear phrase with 2 pages of unclear phrases that I don't think was actually helpful for bringing enforcement actions. And so, I'm optimistic that we will find a way in this administration to chart out a path that is textually grounded in the statute and, reasonable and appropriate so that we can bring enforcement actions that are not like expansionist and crazy, but grounded in the text of the statute and that actually benefit consumers.
I mean, a revived, sort of fully theorized Section 5 would be a sort of remarkable development at the FTC. And as you say, that's something that's not available to DOJ. I want to jump to another one of those tools in the toolkit that you mentioned, or something that some people see as a tool in the toolkit, others think is not in the toolkit at all, which is competition rulemaking. So the FTC, under the previous administration, issued a competition rule that would ban, I think, a substantial majority of non-compete agreements with workers, with those who labor. And my own 2 cents on that is that I generally think non-competes, particularly for certain large categories of workers, harm the workers. But I'm not so sure there's a competition rulemaking authority in the FTC Act. And if there is, I'm not sure it reaches non-competes, including because what I don't like about them is that they harm workers. I think it's much less common for them to harm competition in a traditional antitrust sense. But the rulemaking was issued. It ran into some trouble in court. And in the last couple of weeks, the FTC has announced, sort of issued a request for information, calling for more input about non-competes in the economy. And it has withdrawn the rulemaking effort that was launched under the previous administration. So at a very high level, what's going on with rulemaking? Is that an important piece of the toolkit? What's the right destination for the rulemaking project? Just help us understand how we should think about what's going on the rulemaking side.
Sure. So I think I share your concerns. And for me, irrespective of whether we have the ability to engage in competition rulemaking, I just think it is almost always a bad idea that antitrust does not lend itself well to one-size-fits-all approaches. That if you were going to develop a competition rule that was truly nuanced and accounted for all the varying circumstances, right, it would be unwieldy. It'd be so large. The alternative to that, right, is like very broad, bright line rules, and that's kind of the approach the now late non-compete rule took, which is essentially to ban all non-competes. And I mean, as you alluded to, like I just don't think that's correct as a matter of law or policy. Some non-competes are good. Like especially you think about selling a business, you want reasonable assurances that when somebody sells their business to you, they're not going to turn around and undermine the value of what you just paid for by taking their name and reputation elsewhere and competing against it. So there's other contexts where you have, sophisticated, high-level employees with lots of inside knowledge.
Executives being paid $1.5 million a year or whatever.
Little rocket scientists, right?
Sure.
Who have a lot of bargaining leverage in the negotiation process. So it just doesn't make sense to bar all of them. But at the same time, non-competes have absolutely been overused and abused, and it's a real problem. And this has been sort of an open secret in the antitrust bar for a long time. You counsel clients on how to deal with this, and the reality for a long time was, well, Yeah, I mean, if you read the case law, you probably shouldn't do this, but is one of the agencies going to come after you? No. Can this person afford to sue you? No. And so they just proliferated because the risk profile for companies was relatively low. So this, I think, is actually a really good example of sort of the more, it's a concrete example of the sort of philosophical differences that we were talking about earlier, where, I think those of us on the commission now and those who were on the commission in the Biden administration, but we all agree that non-competes have caused problems. There have been times when they've harmed workers, they've even harmed competition, and that we have to fix this problem. Their approach was the sort of like spray the bullets everywhere, stop all the non-competes. And our view is that's not a legitimate exercise of our authority. That's not going to have a net gain. It's going to cause a lot of unintended consequences.
Might not survive in the courts.
Might not survive in the court. But what we can do and should do is bring cases. And so, there were, I think, tens of thousands of comments on the rule, but all of those were comments on whether that rule was good. What we want now are people giving us tips, right? So we put out this RFI, and what we're looking for are employees essentially to come tell us and say, hey, I was subject to a non-compete and I was, making sandwiches at a sandwich shop and I couldn't go to the shop down the street. Something that's like crazy and unreasonable. We want to know how pervasive this is, what the hotspots are, what industries are of most concern, what sort of terms are being applied. And most importantly, we want tips for investigations so that we can bring cases, bring enforcement actions that have concrete benefits to those workers, and then develop the law. And ideally, we don't have to bring a lot of cases because people stop doing it, right? We get some verdicts on the books, and then, hopefully these companies are well counseled, and lawyers say, hey, you can't get away with this anymore. Here are the parameters for what's permissible and what's not, the right scope and duration, all of that. And we can get to a world where we are enforcing the law to protect workers from onerous non-competes, but we're doing it in a way that's measured and appropriate and not overly burdensome. And people have, awareness of what that principle is and can apply it in the businesses they run. And then everybody wins across the economy.
And I hear some of those themes as reaching beyond non-competes in particular. One theme that the last couple of administrations have emphasized on the antitrust front is the importance of returning some attention, some enforcement resources to labor markets and focusing on practices that might harm workers as well as, or perhaps instead of, consumers. What is your reaction to the project of reviving labor antitrust? Are you supportive of that? Are you skeptical of it? I realize this divides opinion very deeply, but I hear themes in your answer about non-competes that goes exactly to that stuff.
Yeah, and I think the non-competes are a great example. It's an area that, this administration takes workers very seriously in a way that past Republican administrations have not. I think that's a great change on the right and within the Republican Party. And so it's essential that we make sure we are using the statutory authorities we have to the full breadth that they offer to protect workers wherever we can. That said, right, as I mentioned earlier, antitrust is not a panacea. We have a Department of Labor that deals with labor issues broadly, so we don't want to overstep our bounds. But where there's a discrete antitrust issue that deals with harms to laborers, you can have a labor market, you can have no poach agreements, the non-compete issue, right? We have areas where we can step in and take action to protect them in that situation.
So we've talked about many of the antitrust hotspots. But the big one we haven't talked about at all is tech and digital markets, because if there's one point of agreement that seems to have animated the antitrust revival or revolution, it's the need for serious and sustained attention to tech markets, digital markets, platform markets. These are described in different ways.
It's an under-discussed topic too.
And yeah, less these days for sure. In fact, let me ask you that question explicitly. So we're seeing right now an extraordinary moment, right? There are two federal enforcement cases against Google, one against Facebook, one against Apple, one against Amazon. Is this a moment? Is this where, this wave will wash through and then, we'll have done what we need to do on the tech side as long as we get regular antitrust back into, whatever condition one might think desirable? Or are we going to see going forward a certain sizable percentage of agency enforcement resources specifically focused on tech markets, large platforms, whether it's, search markets now, AI next month. Is this a one-time fix and a brief political moment, or is this a movement in the antitrust project of its center of gravity?
So I'm going to give the lawyerly answer, which is it depends, right? And I actually think there's two questions in there. One is dealing with, is this antitrust moment a flash in the pan? And the other is what's going to happen after these cases are resolved. For all of the reasons we've talked about already, I don't think the moment is a flash in the pan. I think that it is growing out of, deeper sentiments and concerns about economic fairness and economic regulation and policy at a very broad level, and this is just one manifestation of it. I think that's a generational thing. I think it's only going to amplify, so I don't think it's going away.
So you think people should take antitrust, they should take advanced antitrust, they should take antitrust seminars, because this is going to be with us for some time.
For tech specifically, in an ideal world, the government wins all of the cases, industry learns their lesson, kind of like Microsoft did a pretty decent job after the case in the 90s and was a better corporate citizen afterwards for a while. And so you would hope that they would learn their lesson, they would abandon exclusionary conduct and compete on the merits, and we would live in a, something approximating techno-utopia or something like that. The reality, though, is we'll see how the cases turn out. Obviously, DOJ has 2 wins under their belt already. We'll see how the cases turn out, but the issues aren't going away. When you ask, are we going to have a division? Well, actually, we do literally have a technology enforcement division. So I guess the answer to that question is yes. We do have resources specifically dedicated to these issues, but it's not inappropriate because these are the largest corporations in our economy, in the world, in the history of man. These are the largest and most powerful economic actors, and it is precisely when you have that much aggregation of economic power that you have to be on sort of heightened alert for its abuse. And so I would hope for a world in which, we win our cases, they learn their lesson, everything's great going forward. The reality is that for both those companies and all others in the tech space that would, dream of replacing them, these are likely going to continue to be new issues. And to make another pitch for your antitrust classes, the thing that makes antitrust so interesting is that every case is different and markets are constantly evolving, the economy is constantly evolving, technology is changing. So it's never static, right? Both the substance of what you're dealing with and then the way you have to apply the same enduring principles to those changing facts is always developing. And so we've got new things on the horizon now that we're already seeing that are going to require new and creative thinking under the antitrust laws about how they apply to these new markets. And there's going to be more in the future. And so in some ways, as much as you would hope it's never going to go, or that everything's going to be better and no one's going to violate the law, there are going to be new issues inevitably and new challenges for us to address.
You used the formulation of the defendants in these cases, in some sense, learning their lesson. And I want to pick up on that with something that couldn't be more timely and hot off the press, which is the Google search litigation. I'll stay away from the FTC cases because I know those are in litigation and you'll be limited in what you can say. But there's a lot of oxygen being used and processed right now as the world reacts to the 2 opinions that have come out in the Google search litigation in particular. So this is a case brought by the Justice Department originally under the first Trump administration, litigated and prosecuted by the Biden administration, that resulted in a DC federal district court decision holding Google liable for inducing exclusivity with its control of default distribution slots for search. And that opinion was followed by a remedial decision that instructed Google basically to cut it out and to provide some affirmative support to rivals, but didn't do what a number of commentators on both left and right had called for or alluded to, which was require a structural separation of the business, particularly the separation of the Chrome browser or the Android smartphone business. Now, the reaction to that seems to be divided. between those who see that remedy decision as a calamitous betrayal of the liability finding, and those like me who look at that and say, look, if you litigate a narrow exclusivity case that doesn't in its heart have much to do with structure or acquisitions, then it's not really on to complain when the result of that decision is the standard remedy for an exclusivity case, which is cut it out with some bonus stuff thrown in. But this is deeply controversial, and people very reasonably feel all kinds of ways about both the liability and this big remedies decision that some see as a missed opportunity to break up Google. Let me just ask you on a blank canvas, what do you make of at least what we've seen so far in the Google search decision or just in the Google search litigation? And what, if anything, does it tell us about the power or limits of antitrust in digital markets in general?
Sure. Look, I think those two decisions are going to become known as sort of the Dr. Jekyll and Mr. Hyde of antitrust. I don't know how you square them, but not for the reasons you identify. I agree. I always thought that a structural remedy was a long shot in the search case. If there is not a structural remedy in the ad tech case, it will be a miscarriage of justice. But in the search case, I always thought it was a stretch for the reasons you articulate. That said, what concerned me the most was that the liability decision centered around the holding that these default agreements, this exclusivity arrangement between Google and Android, Apple, Mozilla, all these different distribution venues for search, that's what was held to be anti-competitive and locking out competition. And then the remedy, the consensus was, well, at a minimum, the judge will ban the exclusivity arrangements. He will prevent having these defaults, being able to pay for default status. And then he didn't. And it's really sort of you had one job. It was shocking to me to see the judge drop the ball on that. I know he's talked about exercising judicial humility. And to me, that includes having the courage to actually enforce the law and follow through on the liability holdings to craft a remedy that's responsive and not write something that really looks like you changed your mind in the intervening months and are trying to let the defendant out with a slap on the wrist.
So you're on team betrayal, I
Betrayal,
hear.
but for different reasons. I thought the structural stuff was a stretch. That didn't surprise me. It doesn't concern me as much. That would be a very aggressive remedy, not unwarranted, right? I mean, the Justice Department made a very good pitch for it, but I thought that was sort of the edge case in a remedy universe. But to not have a ban on the default agreements just doesn't make any sense. And the reasoning was very odd too. It was that, well, some companies will be harmed. So that to me means we now have an antitrust precedent, a pending appeal, that says that a monopolist can get out of a remedy to exclusionary conduct by sharing their monopoly rents with others in the marketplace. That is a terrible precedent and completely at odds with the text of the Sherman Act and all of judicial history interpreting it.
So am I right to hear you as having at least envisaged on the front end much more robust behavioral relief, stopping short of something involving a breakup?
Right. I generally favor structural remedies over behavioral. That's largely because behavioral remedies often don't work and they're hard to administer and oversee. This is a very simple injunctive relief, right? You were doing this and it was bad. You can't do that anymore. Right? It's not complex. You don't need a compliance monitor to get into Google and micromanage things. It's a very simple, you can't do this anymore.
So you contrasted the Google search case with the Google ad tech case. Do you want to just give us a little bit of a flavor for those who haven't had the pleasure of trawling through that recent opinion? How is that case different, and why does that difference matter?
Sure. So in the ad tech case, the central issues revolve around Google's control of what's called like the ad tech stack. So basically, every time you load a website and ads get populated, there's all this stuff happening in the background where the website owner and the advertisers are all getting put into a digital auction process where bids are placed on getting an ad that matches the user viewing the page and the content on the page, all of that. The auction is completed, an ad is served, one company gets billed, the other gets paid, and then Google takes a cut in the middle. And here, right, this is a position that Google acquired by acquiring multiple companies over a number of years, buying up different parts of the ad tech stack, and then leveraging their monopoly position in markets like search and their market power with YouTube to to basically force advertisers all into their platform. And once you're on their platform for one part of it, it was more economical to use it for everything you did. And they kind of drove out all competition for advertising on the open web. Judge sided with the Department of Justice under that complaint, and now we're awaiting the remedy. Here, right, a lot of the anti-competitive conduct they were engaging in derives, one, from inherent conflicts of interest that exist from owning all the different parts of this auction process, and two, that came about because they acquired these businesses. It wasn't just natural organic growth. And so I think both of those facts counsel heavily in favor of a structural remedy.
Some of the reaction that I read goes in something like the following direction. Hey, the modesty of the relief we're seeing, certainly the Google search case, lends some support to the idea that antitrust litigation through the court system ain't going to do it for different values of what it is. I think people have different things in mind. It's time to go back to Congress and ask for legislation in tech markets, which is something that I know you have deep expertise in. I've been pretty skeptical of most of the proposed legislation that has been in and around the tech space. How do you feel about this congressional legislative piece of the puzzle? Is it time, or might it soon be time to revisit that discussion? Has the air gone out of it? What's Congress's place in all of this?
Sure. I mean, well, first of all, Congress always has the preeminent place. They set the policy, and then we enforce it. I think I wouldn't throw in the towel yet on enforcement through the courts. We have more cases that are in the works. There can be appeals. I think back to the FTC's pursuit of pay-for-delay cases, where we lost the first several, and we kept at it because we felt very strongly this is anti-competitive and it's harming consumers. And we eventually got a circuit split, and we worked it up the Supreme Court, and we won. So I don't think that one lackluster remedies opinion is the death knell of enforcing the antitrust laws in the courts. We also have state AGs, and we have private plaintiffs. One of the best things about the search decision is that it opens the door for follow-on suits by private plaintiffs. So there will be other judges who have an opportunity to impose remedies that could be different from Judge Meador's. But yeah, on top of all this, right, there's Congress, and we've seen a flurry of activity in the last 5 to 10 years over whether we need to update the antitrust laws or supplement them. I did always chuckle when I was in the Senate that a lot of what was referred to as antitrust legislation actually was not. It had nothing to do with the antitrust laws that existed or changing them. It was really statutory efforts to address specific competition policy problems. And I do think that remains a viable option in discrete instances and tailored to certain markets. And there were several bills that got pretty close. I think probably the one that had the best chance of passing was the Open App Markets Act. There's others like with kids' online safety, dealing with those issues. And so I think there are pretty decent odds that one of those gets across the finish line. And of course, if Congress wants to give us additional powers, we're happy to use them however they see fit.
While it's true that these cases and most of those bills that you mentioned were aimed at what you might think of as like the Google generation of tech products, Google, Facebook, Apple, Amazon, there's a lot of oxygen and attention gathering around AI right now. I have struggled to identify a specific concrete competition concern pertaining to AI as we see the emergence of this sort of radical wave of new technologies. Are you more worried than I am through an antitrust lens?
Well, I look at it through two lenses because we have the consumer protection side as well. And so we're thinking about it on both fronts. And at a high level, I think we have across the administration a uniform view that what we know we don't want is the government micromanaging the development of AI. We don't want to be dictating how models are structured or trained or developed or all of that. I'm concerned about, on the consumer protection side, how is it used? And we already have been bringing cases and have investigations into basically scams and frauds that are being powered by AI. So that's a really big concern, especially when it's targeted at kids, for example. So that's one issue. On the antitrust side, I'm looking at it the same way I look at any other nascent or developing industry, which is, you don't want to come down heavy-handed, but you don't want to allow a large incumbent to unduly influence the development of the marketplace. So you want to have competition so that the cream can rise to the top. I think we have a very diverse AI sector at the moment, but it's not hard to imagine that consolidating over time. And some of that is probably necessary to fuel scale and innovation. But you can imagine reaching a tipping point. And I don't have an answer to the question of like, what's the right number of AI companies? And I don't know if there is an answer to that. But what we eventually will be tasked with looking at is whether specific actions or potential deals in that space do cross a threshold where they risk harming competition and thereby hampering innovation and slowing down the development of the marketplace in a way that actually benefits consumers rather than just consolidating power to a few large technology companies.
So before I throw it open and welcome some questions for our last 10 minutes, I want to dip into the mailbag of questions that we received. Karina Gerhardt asks, would you share your thoughts on the continued use of the FTC's in-house court system? That's I still think I'm working at the FTC, administrative law judge, sits at the FTC as an administrative court with appeal up to the commission. How do you think about administrative litigation at the FTC?
It's a good question. I'm going to be careful here because a lot of things around that are in active litigation.
Sure, yeah.
And I don't want to get ahead of anyone. But look, I think the most important thing is that we have the ability to reach judicial determinations that allow us to enforce the law and benefit consumers. I think whether it's through the Part 3 administrative process or going into federal district court, we have the ability to do that. There are features and bugs of both. But at the end of the day, I feel confident we can achieve our goal through either course.
Matt Rosenthal asks, how does Mr. Meador's view of antitrust enforcement, particularly consumer welfare, materially differ from that of prior Republican antitrust enforcers?
It's a great question. So one of the things I explore in my paper is how, and there is some variation between sort of some of the academic literature and how courts actually apply this, but the vision of consumer welfare that Judge Bork advanced in the antitrust paradox was actually what economists refer to as total welfare. And he just kind of laundered it under this title of consumer welfare, which sounded really great and populist. But this notion of total welfare really encompasses, efficiencies or benefits that accrue to any participant in the marketplace, not just consumers. And so you can have a world, for example, where a merger creates efficiencies that generate returns to shareholders, and it's at the expense of consumers. In my view, that is not a pro-competitive merger, and it's something, if it's harming consumers, we should block. But under a total welfare approach, you could say, well, there's a net gain because some group is benefiting more than another group is being harmed. And so we're okay with it from like a holistic economic perspective. I don't think that's the right policy outcome. I don't think that's consistent with the text of the statute. It's certainly not consumer welfare. And so we should have a vision of consumer welfare that is more faithful to the statutes and to that actual notion of ensuring that the antitrust laws accrue to the benefit of the average person.
So that is a great segue to, I promised I would save 10 minutes at the end, and we have exactly 10 minutes left. I would love to hear your question, so raise your hand. And let's start down here. I think we have a microphone somewhere. The microphone?
Where
at? The microphone is coming. The microphone's coming your way.
Where is it?
Hey, thank you very much, Commissioner. Just going back to the Google ad tech situation, maybe as like a representative example, how would you counsel, CEOs and boards sort of ex ante when they're looking at some business plan, maybe produced by smart MBAs and consultants, saying, we can create this great ecosystem, reduce prices for the consumer, and build a fantastic business. How would you counsel them to maybe calibrate or change those efforts under this new regime?
Well, I'll say that some of the most anti-competitive schemes have come from very smart MBAs and consultants, so be careful to start. But look, I think the underlying question is this notion of competition on the merits, right? If you're a business and you're working as hard as possible to benefit your consumers and outcompete your rivals to deliver the most benefit to your shared customer base, you're probably on safe ground, right? Where you stray into the territory of potentially violating the antitrust laws is when you're not trying to deliver the best outcomes, you're trying to leverage existing market power to prevent your competitors from being able to deliver the best outcomes that they can, right? So if you're focused on how I can do the best job to serve my customers, you're probably in safe territory. It's when you get into this realm of like, well, I've got a really high market share, and if I locked up this distributor, the other guy wouldn't be able to get to the market as easily, and that would really help me. That's not pro-competitive, that's just entrenching market power.
So look inward, not at your rivals.
No, you do want to look to your rivals if it's like motivating you, right? You want to outcompete them. Don't look at them too closely because you shouldn't talk to each other. But pay attention to what they're doing and then try to do it better. Don't focus on like your existing market power in a way that lets you, prevent competition on the merits.
Questions? Fiona. There's a microphone if you want it.
Just a couple of questions. One is on mergers and whether and how this administration differs from the Biden administration in the sense of not wanting to impose taxes on transactions and not want to impose unnecessary burdens, excessive second requests, etc. Gail Slater over at the Antitrust Division has said, we're open for business, we want to clear pro-competitive and neutral transactions quickly. What is the FTC's position? That's question one. Question two, very brief. What is your position on the need for close coordination, collaboration on international enforcement? It's something that prior administrations really held dearly. I feel like we've been doing much less in that area recently, and we've been ceding ground to others. I personally would like to see the US play a bigger role. Your thoughts on that? Thank you.
Thanks. So to your first question, I think FTC and DOJ are totally aligned on this, that we are not interested in throwing sand in the gears to just try to grind down all M&A, regardless of the merits of a transaction. As I've told many people, most mergers and acquisitions are good. They're good for the economy, they're good for consumers, and we don't want to get in the way of that. Where there is a deal that presents competition concerns and we feel it violates the Clayton Act, we won't hesitate to step in and block it. But otherwise, yeah, we want to make this as seamless as a process as possible. On the international front, I just answered a similar question with some students previously, and what I explained was, I took an oath to uphold the United States Constitution. I am in a role where I have to serve American consumers and American interests, and I do put America first. And so I think ensuring that our enforcement of the antitrust laws inures to the benefit of American consumers is my top priority. But of course, in a world with cross-border deals and multinational corporations, you're going to have some kind of coordination with foreign enforcers. And we want to make sure that we are aligned as possible, especially when it comes to crafting remedies that are going to impact multiple jurisdictions. And so I do think that coordination is important. I think it's important for us to have a leading influence in this sphere across the world. But at the end of the day, it all comes down to what's best for Americans.
We have time for probably 2 more questions.
Thank you so much, Commissioner, for being here. You discussed a little bit your perspective on the AI sector, thinking of it as a nascent sector and giving it the space to grow and see how that market does develop. But there's a lot of markets and economic press kind of bringing scrutiny to whether it's the sort of centaur model, big investments that allow dominant players a degree of control, and whether those are attempts to sort of skirt merger enforcement and potentially blend directorships of these companies. Do you, while you aren't maybe leaning in and actively concerned about the structure of that market, do those sorts of activities raise concern for you?
Great question. So I think it's something we pay attention to closely. I think it's a great opportunity to remind folks that, for both enforcers and courts applying the antitrust laws, we look at function, not form. And so with new technology, there's often new business structures, business models that can present corporate structures or conduct that we haven't seen before. But when you get beneath the surface and look at what it's actually accomplishing and its effect in the marketplace, you can say, oh, well, that's a de facto acquisition, or this is some other form of conduct that we're familiar with, and then we'll evaluate it through that same lens.
Our last question.
Make it a good one.
Yeah.
Raise your hand again.
Yeah.
Hi, thank you as well for being here. I really appreciate your time. I have one question because I was admittedly a little unconvinced by one of the things you said, and I wanted to give you the chance to respond to it and maybe change my mind. So talking about the independence of the FTC, you brought up the argument that I guess diminishing the independence of the FTC could make it more susceptible to democratic accountability, where voters can vote in to change policies in favor of what they see as beneficial to their lives. And obviously, without diminishing the incredible importance of the work you do, my intuition tells me that antitrust enforcement doesn't necessarily win elections. And I gather that it's obviously an exceptionally important issue, but might not be on the mind of the average voter. So at least from my perspective, one of the importances of the independence is to kind of maintain that level of consistency and that level of authority that the FTC does have. So I'm just curious if you have any thoughts about that.
Sure, no, it's a great question. I mean, look, I will double down on the democratic accountability point. I just think that the idea of independent agencies is fundamentally inconsistent with notions of democratic accountability. But that said, I mean, you raise a good point that we don't see a lot of people campaigning on antitrust, let alone winning elections on that basis. But they sure as heck do win elections on the basis of economic policy, right? And antitrust is a significant component of that. It's a very wonky technical discipline. It's hard to work it into a stump speech or a debate.
But it's also fun and approachable, right?
100%, yes. Yeah. But it's a substantial part of economic policy, and that is one of the biggest things that elections are won on. And so, voters are looking at, whether it's president or congressmen and women, what is their economic policy? How are they going to approach it? I mean, there's millions of policy decisions that have to be made every day across the federal government. It's impossible to campaign on all of them. And when we are voting an election, sometimes we're voting on specific issues. I think more often we think we're voting on specific issues, but what we're really doing is voting on that person and their judgment and political disposition and inclinations, and trusting that what we know about those parts of their character will carry forward in how they administer and appoint people to carry out those millions of policy decisions.
This has been a terrific tour of the antitrust space, from Section 5 to big tech to the future of the FTC. Please join me in thanking Commissioner Meador.